Over the past 18 months, the Justice Department has been working to defend the reproductive freedoms that are protected by federal law. As part of that work, we are continuing to vigilantly monitor state laws and enforcement actions that threaten to infringe on women's reproductive rights. Last month, we filed a statement of interest in 2 lawsuits challenging the Alabama Attorney General's threat to prosecute people who provide assistance to women seeking lawful out-of-state abortions. As I said on the day that Dobbs was decided, bedrock constitutional principles dictate that women who reside in states that have banned access to comprehensive reproductive care must remain free to seek that care in states where it is legal. Our brief explains that the threatened Alabama prosecutions infringed the constitutional right to travel. It also makes clear that states may not punish third parties for assisting women in exercising that right. We are also continuing to litigate the suit we brought to ensure that women in Idaho have access to the emergency care guaranteed by the Federal Emergency Medical Treatment and Labor Act, or EMTALA. Idaho's law prohibits abortion even when it is the medically necessary treatment to stabilize a patient's emergency medical condition. Last week, we filed a brief in the Supreme Court to preserve an injunction that blocks Idaho's law to the extent it prohibits doctors from providing the care that is required by EMTALA. The Justice Department will continue to vigilantly monitor laws and actions that infringe on federal protections of reproductive rights, and we will take appropriate action to defend those rights. We are also continuing to advise federal agencies on legal issues related to reproductive health in the aftermath of Dobbs, and we are defending agencies as litigation arises. More than 2 decades ago, the Food and Drug Administration approved the drug mifepristone as safe and effective to terminate early pregnancies. But in an unprecedented decision issued earlier this year, the District Court for the Northern District of Texas displaced the FDA's expert judgment and blocked the agency's approval of mifepristone. We quickly obtained a stay of that decision from the Supreme Court while the case is on appeal. And now that the Fifth Circuit has affirmed the District Court's decision in part, we are seeking Supreme Court review to ensure that mifepristone remains available on the terms approved by the FDA. The Department of Justice will not cease its efforts to preserve access to mifepristone and defend the FDA's expert judgments. We continue to work to protect healthcare providers and people seeking reproductive health services. We continue to enforce the Freedom of Access to Clinic Entrances Act, known as the FACE Act. That law prohibits anyone from obstructing access to reproductive health services, including abortion services, pharmacies that provide reproductive health care services, and pregnancy counseling services, through violence, threats of violence, or property damage. We are working to ensure that prosecutors across the country are equipped to bring FACE Act cases, and we have emphasized that Civil Rights Division attorneys are always available for consultation and technical assistance.